that a senior advocate, means senior, not designated senior, but a very experienced lawyer and a very successful lawyer from Delhi is about to give a lecture on this consumer protection rules, consumer protection laws. And therefore, there has been kind of a gate crash.
You see, gate crash I always remember from my college days, so please don't use this word, use any other word.
We all welcome, on behalf of all the newly enrolled advocates and also the law students from different law colleges. I welcome Mr. Sanjiv Sahay, who is a very successful lawyer in Delhi. He practices in Supreme Court. He also has several cases in High Court and different other courts in different states. He also comes to Jharkhand High Court to argue several cases where he's engaged and briefed to argue those cases over here. He has a vast experience, and it is very fortunate that all be proud. I feel proud that he is basically from Jharkhand. He is basically from Hazaribagh, and he has done so well in Delhi. For the rest, I leave Sanjeev, but we are already delayed, and so I request Sanjeev to take over.
Thank you, Rajesh, and for all kind words. I don't know whether I actually deserve all this what you have said, but I accept it with all humility.
You deserve more.
Thank you so much. So, friends, now you are there in the profession. Some are there in the profession and some going to join. Let me start with, this Consumer Protection Act and what it means. As a lawyer, we have always been defined that there is a grund norm and there are acts. Like grund norm is the Constitution. Constitution provides the basis for every act of the country. If any act is ultra vires or is contrary to the Constitution, it's bad in law. So we flow from there, and definitely if you read Directive DPSP and definitely Article 36 to 41 and 45, then you will find that there are a lot of bases to this kind of legislature, which could be called a social legislature. But CPA is not a new thing. Even when Kautilya wrote his Arthashastra, he had dealt with this issue there. In fact, I was giving a lecture in Indore Law College long back. That must be 10 years back. And I was doing a research and I realized that whatever amendments we are bringing now was actually envisaged and postulated by Kautilya at that time. So history is rich. What happened is that in modern India, we never translated these old laws and brought it into a legislative form. So we carried the vestige of English postulated and created law. Now English people grew and went beyond those laws which they created, and we remained stuck. So in that metaphor, I can say that this 1919 amendment, a 2019 amendment, which was almost like a new act, is actually a paradigm shift from the old one. Old act was about 36 section. This is 106 section, and you can understand from that perspective only that what all they have done. Now this act, as a lawyer, whenever we grow up, what we have to always do is read the bare act. And that's the cardinal principle. I remember long back when I was young in the profession, and I was talking to a very, very senior criminal lawyer. Well, that lawyer had appeared for Indira Gandhi, unfortunately he is no more. He had appeared for Indira Gandhi, George Fernandez, so you can understand his mentor. And I was discussing with him on Article 2 to 6 of the Constitution of India. And somewhere I said some interpretation of it, which he was disagreeing. But he said, son, let's open the Constitution and read it. I said, sir, you would obviously know. He said, no. I may know, but my mind is always colored by the curtain of the client's case and fact. So the moment we change that message, we may get a new interpretation. So let's read it. And that's the importance of their act. Everything flows from here. Now this their act, if you see, this can be easily divided into 4 parts. First is definition. We all have to read it. Second part is the central government and state government, their authority and what all they can do. A new segment brought in with a lot of enforcement power. Third category, which we deal as a lawyer every day, consumer protection, which is Consumer District Redressal Forum, State Commission, and National Redressal Forum. In fact, Rajesh Pandey has already given you the brief background, brief of the entire act. So I will run short of that. And then comes the fourth and fifth part. Fourth part is a totally new concept brought in now, product liability. We have been talking about this product liability and service liability, but there was no legislative enactment on that. In fact, when I will be in the course of my thing, I'll tell you 2 cases. Bhopal tragedy case, gas tragedy case, we all have read about it. That incident would have actually fallen in this section, which now they have incorporated. Including there was an airlines and there was a failure in landing which led to crash. And there also, it was a case of product liability. But India did not have product liability law at that time. So it was not that we failed in those 2 issues, but Supreme Court had to rise above the legislation, invoked causation law, invoked principle of natural justice and equity, and give relief.
Excuse me, Sanjeev. So sorry. So sorry to interrupt. Actually, I have started from Consumer Protection Act of 1986, but I still, it's 2019.
Okay. So that's covered. Then I will cover the 2. I will cover to 1919 only. I'm not going to tell the history of 1986.
Right.
You have covered enough. Right. So that is the third part. Product liability, service liability, product seller's liability. That is the third part which has come. And last is the miscellaneous. Now miscellaneous also cannot be missed, because it brings into ambit of law 2 important things. A, product imported, and e-commerce platform. Okay, so this is the aspect of law which we are dealing with now. Now the simple question what we see is, who are the complainant? Section 2(5) of the Ware Act says, remember one thing, in Ware Act, Section 2 is always a definition section. Okay, that's it. Section 1 always says where it will be or which territory of the country it will be applicable, and Section 2 says what is the definition clause. So we'll just run through a relevant definition clause and like, who are the consumers? Now here you will see consumers are basically 4-fold. A, customer himself. 2, a voluntary consumer organization. 3, central or state government. And 4th, 1 and more consumer. Now 1 and more consumer I'll come because this will come in more specifically in a class action suit, which has been introduced by way of amendment, not crystallized. So these are the 4 set of complainant, what we call. Now, if you define, because the first thing what we read, when we read the word complainant, we saw the word consumer. Who is consumer? Consumer have been defined by Section 2(7). And now, you have to just specify it, saying the person who purchases the goods or buys a good or any service for his use or for the use of the person whom he authorizes. That is consumer. Important thing is that consumer does not mean that the person who has dealing with commercial purpose. So consumer is, if I, Sanjiv Sahay, purchases a mobile, I'm a consumer because I'm using it for my personal use. But then who are commercial? A very classical example came in was Ola, Uber, these taxi services, these taxi aggregators. Now, if Sanjiv Sahay purchases a taxi or hires a car and operates it as a taxi for his own survival, even if he engages a driver to run and operate that taxi, he is a consumer. But if he is a car aggregator like Ola, then it becomes commercial purpose. Another example of commercial purposes, which happened where it was a judgment also, and I dealt with one case where, let me put my case only. In that case, it was that this company purchased a Mercedes for its managing director. Now there was a defect in the product. That defect was not rectified, we filed a consumer complaint. The objection raised by the other side was that it's no commercial because it's purchased by the company. So my argument was only this, that may be purchased by the company, but for the personal use of the direct managing director. And then we finally succeeded in National Commission. State Commission dismissed our case, National Commission succeeded. So you have to be very clear that whether the product is being used for a commercial purpose or not. If it is being used for commercial purpose, then you are out. If it is for your survival, your personal need, your daily resources and income, it is consumed. Now this classification is important, but because in India, larger section of the people are purchasing things like an auto driver who is operating it. You cannot treat him as a consumer, not commercial. Where he will go? So the consumer has been defined, a person who avails goods and services for consideration. Now this is very important. Entire Consumer CPA, Consumer Protection Act, postulates three things. A, you have bought or hired the services or good for consideration. It should not be free of charge. So remember that. Two, it is not for commercial purposes. And three, there is defect, deficiency, which has caused loss or harm to you. So if you have these three ingredients, when a client comes to you, you have to check these three things. A, he is a consumer. B, goods and services hired for consideration. And C, the defect or deficiency has led to some kind of loss, injury or harm. If you see these three golden rules, you are successful in your entire practice of under Consumer Protection Act. These are the only golden three rules. Everything is develops around this. So, I have given you a definition of consumer. Who are the consumer? And what are the exception to the consumer? Because I was reading to consumer, definition of consumer in 2.7, and the complaining, and we read one thing, that one and more consumer, what happens? Now this was a concept which was brought in, which is section 254, Roman 5, which says one and more consumer, where there are numerous consumers having same interest. Now mark the word. One or more consumer, where there are numerous consumers having the same interest. There, any consumer can bring a class action suit. Now, what is class action suit is defined under section 12 and what is to be done. But again, what is a class action suit? Like assume you have purchased a flat in a building tower, which has say 100 flats. You are only a single purchaser of one flat only. But that flat has several defects and deficiencies in terms of design, in terms of layout maybe, in terms that they had said that it will be 100 square feet, but it is 90 square feet. It can have any kind of defect or deficiency. Now, you can file a complaint representing yourself, but on behalf of all. You don't have to bring necessarily all the 100 flat owners to the court. This is class action. Class action, what you have to see is, again, golden, remember 3 to 4 rules. I would try to put it in 3. A, all are consumer. Now we know the definition of consumer. 2, all have the same or similar grievances, like you say, defect, deficiencies, injury, harm, same and similar. All are asking for same kind of relief. So you can bring a class action. Now this class action was actually brought in because of this builder cases, this airline cases, where there's a lot of people involved. Lot of people, injury has been caused to a lot of people. It can be brought by single or one person, and everyone will benefit. In fact, the famous judgment definitely was Vikram Singh Malik, which actually defined a test. And it says, what is the test of section 12, 1C, which defines class action? And it says, sameness of interest. That is what it is, sameness of interest. Interest means all have. Now I had expanded the word interest by saying they all are consumer, they all have same grievances, they are all asking for the same kind of relief. So sameness of interest. It does not say same interest, it says sameness of interest. And that's very important. That gives a lawyer a freedom to bring multitude of people on a common platform when they may be like, I may have a defect of design in my flat. You may have a defect of seepage in your flat. The other person can have a defect of electric connection in his flat. So you can bring them all together in a common platform. That is what we call class action suit. Now, coming to what is so. Now I will try to emphasize primarily on section 28 to 73 of the CPA. 28 to 73 is divided into 3 parts. District Consumer Forum, State Commission, and National Consumer Forum. Remember one thing, the procedure involved in all 3 is common. Only the jurisdiction changes, both pecuniary jurisdiction changes, and the appellate jurisdiction changes. Now with CPA 19, the enforcement power and everything has been made common. Like all will have now power of review. But coming to this, that what is there under a Consumer Protection Act before a district forum? First thing comes, when we draft a petition, what all you should look as a lawyer? A petition will have 5 parts. A, which defines who is the complainant and who are the respondent. Correct? 2, brief facts. It starts from purchase of the good or hiring of the service till the default or deficiency occurred and noticed. The default or deficiency occurred, noticed, brought to the knowledge of the third is cause of action. What is your cause of action? And what is the last date of your cause of action? Because remember, last date of your cause of action defines your period of limitation. When we read section 68 of this CPA, you'll realize that the period of limitation is 2 years. To have that limitation, the last date of your cause of action is because very, very relevant. We normally don't pay attention to that, but keep that in mind. Because when you do the last date of cause of action, then you come to the next round, which is limitation. What is the limitation, when it starts, and are you within limitation? Thereafter is the jurisdiction clause, whether this court has a territorial and pecuniary jurisdiction. Territorial, whether I am within the local limit of that court, and pecuniary, whether I am within 1 crore, 10 crores, or above 10 crore bracket, depending where I'll go. Last legal paragraph is your court fees. Defined under CPA Rules 2020. If you see Rule 8, there is a whole definition. What is the court fees to be paid? It's provided there. Definitely thereafter is the prayer clause. And you should be very careful with your prayer clause. That's why I said bring it in 5 parts. If you formulate your prayer well, the judge will understand what relief you are asking for. Like, first prayer should be that declare that the opposite party is in deficiency of service. Important that there should be a declaration. Second paragraph then should be asking for compensation, refund, or replacement of the goods, or whatever corrective action you want in terms of which is very effectively provided in section 39 of the CPA. When we will come there, we'll read section 39. What are the reliefs the court can grant? Now the ambit of relief has really expanded. So that is the second ground, compensation. And third ground is what are the additional relief you want from the court? Because now you will have product liability and you have unfair trade practice, you have a restrictive trade practice, you have an unfair contract, which all has been brought in this act. So the ambit of relief has also increased. Read section 39 very carefully. You'll get a lot of ideas from there. What extra relief you can ask as a lawyer. We should not remain in old school of thought. If court chale gaye, compensation maan liya, wapas aa. So this is how it is. So section 34 of the Act defines what is the territorial jurisdiction, where you can file. Now here if you see, the court has been, the legislation has been totally in favor of the complainant. It can be filed where the opposite party resides, where the cause of action has arisen, and where the complainant resides. Now, last is important, where the complainant resides. That means complainant doesn't have to chase the buyer or a seller. The buyer and seller has to chase and come to the complainant. So this is the jurisdictional aspect of it. Now to make the life easier, if you see section 35, it has given a provision for filing e-complaints and petitions. Means you can file through electronic mode, wherever you are. You are in Jharkhand, you can file your case in National Commission through electronic mode. Rule 8 provides how to do it. So they have made it, and in fact this whole thing of having an electronic filing, electronic service, and so on and so forth is actually an outcome of pandemic more than otherwise. There is a silver lining to pandemic for lawyers. There is a lot of hardship we all facing too. It's not that it's not, but there is a silver lining. Filing has become streamlined. Filing has become much easier. There was a case in Supreme Court where the person filed from Barmer, Rajasthan, for a Jawan, an army Jawan who was posted somewhere in Leh or Ladakh. Filed it in Supreme Court and got an order. So that's the advantage, that's the silver lining we have for pandemic. And because of e-filing and virtual courts, that you can practice. Now India is your domain. It is not Jharkhand. India is your domain. Broaden your horizon, you can be anywhere. But remember, like I said, that there are 5 components to a complaint or a petition which you file. But remember, 5 components which I told you is always has one thing in its background, 2 things in its background, which you should know before you draft. A, the act itself. What does the act say? And 2, what are the judgments which the court has passed on that? If you read the act and if you have read at least 2 judgments before you draft, your drafting will be of a very high quality. Because then what you start doing is, you start using judges' language in your drafting. Like when I drafted, in fact, Rajesh Pandey and we were contemporary, and he knows that we used to do the same way. In fact, we used to say, like one person said that, he was a motivational speaker, and he was asked that how do you create so many things and such brilliant issues on leadership and all. So he said, I'm a thief. Everyone was shocked. Then what do you mean by you are a thief? Well, you see, I steal all this thought from Bhagavad Gita. In fact, the best book, one of the most celebrated book written on this recent time, on 7 steps to leadership, he says, I got the inspiration from Bhagavad Gita. So irrespective of that, we also lawyers, we are thief. So I used to practice like this, that initially we would read the judgments, 3-4 judgments, pick up the lines which the judge has said, which I can incorporate in my complaint or a petition, and then draft my complaint. Because when you are arguing in the court and you are reading the paragraph of your complaint, and then you read that judgment, judge will relate very fast. So 5 aspects to drafting and 2 salient features: reading the bare act and reading the judgment relevant. So coming back to section 35, as I told you, which primarily says 4 parts. A, what is the territorial jurisdiction? What is the pecuniary jurisdiction? Where the complaint can be filed and how it can be filed. Thereafter comes para 36, section 36. Now section 36 says that the quorum should admit or reject the complaint. Now admit or reject means court can issue notice on your complaint or court may not issue notice on your complaint. But this should be done by the court within 21 days. Now here I'll tell you, though the entire act says that the petition should be decided in 30 days and all 90 days, no way it's followed in India, unfortunately. And that I'll blame Supreme Court. That any law which the government makes, Supreme Court keeps on saying it is directory in nature, not mandatory in nature. Like Order 8, Rule 1 of CPC came that, written statement has to be filed in 90 days. If you don't file, you suffer the consequences. Supreme Court said, no, this is directory in nature. Hindu Marriage Act says 66 months you have to decide everything. Supreme Court says, no, these are all directory. Now, everything can't be directory. There has to be something strict there. Like I remember I was doing a matter of extradition in England. My God, the barrister would say, I was telling him that, look, I need a day more to draft this, finalize this written submission. He said, no question, they'll throw me out. One day. And India will say, oh, 1 day, 1 week will take it. So this adherence to timeline is not there.
So section 36, I will say only for the purposes of that three things. A, that the court can issue notice, that is admit the petition or reject the petition. B, before rejecting the petition, the court has to give you personal hearing. And important is the default clause. If the court does not reject the petition within 21 days, then it's a deemed admission. So that is your section 36. Now comes to section 37. 37 has been brought in as a very interesting concept of mediation. We all know section 89 of the CPC has been brought in, where mediation has been made part of our existence. ADR, alternate dispute redressal. It's a very, very vibrant field. It is a growing field. It will actually, already in Delhi, it has been very, very successful. And it is being replicated all over the country. So, this ADR or alternate dispute redressal mechanism or mediation has been introduced here also. So when we'll read state commission, district forum, state commission, national commission, everywhere there is a special provision of mediation. And thereafter also section 74 onwards, the CPA provides the mediation process, how it has to be done, conducted, who will be the mediator, and how that procedure is provided. So a lot of emphasis has been given by the statute maker or the legislature on mediation that resolve the issue through settlement process rather than adjudicating process. So now what happens is the court has admitted your complaint, section 36. Court has referred to your mediation, section 37. It does not settle. Then you come to section 38. How this method will be, how the case will be proceeded. So first thing is the opposite party has to file their reply or written statement. That has to be done within 30 days, extendable by another 15 days. That is 45 days. Fortunately, here Supreme Court in one of the judgment made a very strict observation that 45 should be adhered with. So 45 days you have to file your reply. Now, let's assume the good. Now here comes a very important thing. Like if it's a medical negligence, what happens? The court says, appoint an expert body or director, doctors to give an opinion. Because the courts and judges cannot understand the nuances of medical science unless until it is too stark. Like I was doing a case when he was an HOD in AIMS, head of Department of Neurosurgery in AIMS. He performed a surgery on a sportsman. Unfortunately, that sportsman became paralyzed from waist below. He filed a consumer case. I was defending this doctor. And we worked on this and said, look, it's such a complex surgery that even after due care and diligence, still this can happen. We filed several textbooks. The court agreed with us. Now the court there, because of that Supreme Court's judgment and I think Dr. Gupta's judgment and then I think Joseph's judgment, it came in, that you have to do is that a group of panel of doctors will give an opinion whether it is a case of negligence. Like if it's a vehicle, car, then there should be an expert opinion whether there was a negligence or not. Similarly, if there can be a product which can be tested in laboratory, then it can be sent to laboratory. So section 38 now, C to G, crystallizes this aspect of expert evidence. It's very important. So after the opposite party has filed their response, there can be an expert evidence. Once the expert evidence, and you have but anyone has a right to file objection and anything, so I'm just skipping that part. So expert evidence is important. Now what happens? Once there is an expert evidence on record, then the procedure is summary in nature before the Consumer District Redressal Forum. Summary means decided on the basis of complaint, replies, and affidavits. So the parties file their evidence by way of affidavit. Cross-examination is not a rule there in State Consumer Forum. The court will decide on the basis of the affidavit given. Earlier, there was no specific provision. We used to make application for cross-examination if required. Now you have a very clear provision under Section 38 itself, which says that you can make an application for cross-examination, which can be conducted in person before the commission or virtual mode. Now again, this is a very huge shift. Virtual mode cross-examination. We are following so much. I did recently, my client was in Canada and we did in fact, last week of December and first week of January, we did 10 hours of cross. All in 5 jurisdictions, we all were. I was in Delhi, case in Hyderabad, witness in Canada, and we were doing the cross-examination. So here in Section 38, they have brought it that you can ask for cross-examination. It should not be ordinarily granted, but in exceptional circumstances, it can be granted or permitted, and it can be done through virtual mode also. And again, a moonshine thing that all the things 3 months, no one should be given adjournment. If adjournment is given, it should be for a sufficient cause or it should be compensated with cost. Well, all this important thing which has been now brought in, which is there earlier but not very specific, has been 38(9). Power of the district forum. Are they court? And if they are court, then what? So they very clearly says they are court. They have a vested with the power of the civil court. They also have all the proceedings is there as defined in section 193 to 228 of the IPC. They also have a power of a judicial magistrate. Now that is important. A court has a civil power and criminal power at the same time. Normally we know that in India you have a civil, but here they have said both jurisdiction you have. As I was telling you, section 39. And what are the reliefs you can ask for? I said classical was that we used to ask for is classical is that we used to ask for compensation, interest, damages, and all. But I did from A to N. Now the reason for this was, I'm not reading all of them, but reason for what this was because unfair trade practice has also been brought in. So cease and desist and all which was there in MRTP Act has been incorporated here. Because you have a product liability and absolute liability, so that has been also brought here. Because you have the e-commerce, so that also has been brought here. Including, very importantly, and which is I am pointing out, is issue corrective advertisement. That is also important now. That if you have done a misrepresentation through an advertisement, that you have to do a corrective advertisement also. So that's why I said, you can say you can remove the defect, the replacement of goods, price. Now price is also important. If you have taken higher price than the MRP, if you have taken higher price than what has been If you have not disclosed the price and you have charged me, now everything is deficiency. So, as I said, I'm not reading all 39 and with it all A to N clauses. But as a lawyer, whenever you draft, read them, because as I said, it has different application. Where there will be consumer, will have one set. Where there will be it will have another set of relief. But there is contract, there will be another relief you can ask for. If there is what you call a product, so you can fix your relief here. You are not left to imagination, which earlier in our time we were left to. Sorry, forgive me. So important thing is now section 40. Section 41 says that the appeal lies before the State Consumer Forum. And what the period limited brought in this section 41 is 50% of the 50% of the deposit. So whatever compensation has been awarded, when you go to state commission, it's not. Because you may get an order, but to get that order, where the complaint will, what is the procedure the court will adopt, what are the reliefs court will grant. Correct? Now remember, more or less the same procedure is there for State Commission and for National Commission. The difference of jurisdiction. Like when we come to State Commission, section 47 says it is 1 to 10 crores. In fact, very recently a judgment came, I think, so there was a whole, when this act came and there was a revision of jurisdiction. So what happened is that National Commission said that all the cases which are pending before me, which has a value of less than State Commission. And similarly, State Commission says all the cases which are pending before me has to go before the Consumer Forum. So this matter was challenged before Justice Chandrachud. And Chandrachud, applying this whole theory, that an amendment with regard to the jurisdiction should not have a retrospective effect, has said that where the case has already, it will remain there. So a lot of people have been saved from this trouble. Otherwise, as a complainant, as a counsel, we always select our jurisdiction where we have to go. The jurisdiction changes, we all are in trouble. So that's a very progressive judgment of Justice Chandrachud. Otherwise, it would have created a, already is slow. Pandemic has made it sluggish. If Justice Chandrachud had held the judgment of the National Commission to be correct, then the entire proceeding would have been delayed by another 1 year. Identify all the cases. You would send all the documents to those jurisdictions. It will reach there, registered there, then it will go to all the part been lost. So good judgment of Justice Chandrachud, which has come recently only. I think it came in December. So that has said will have a prospective impact. All the pecuniary jurisdiction will be with regard to the cases which are going to be filed and not cases which has already been filed. So similarly, I think section 51 is again a relevant provision which says appeal to National Commission within 30 days. Sufficient cause, the court has the power to extend the period. It says that again, as I said, Rule 11 I had read earlier, now it is Rule 13 which says provide the procedure and the mechanism. And same situation is there at 50% deposit. Similarly is the National Commission. You have to read primarily section 458 for the purposes of jurisdiction. I'm not repeating them because they are very specific there. You don't have to deal with it because I have already dealt in extenso while I was dealing with section 34 and 36 and 38 of the Act. But as I said, so appeal, what happens when National Commission decides? Now here there was two things which has become relevant now. If District Forum has decided something, State Commission has confirmed, or State Commission, first appeal is State Commission. Then National Commission, only it will come when there is a significant question of law involved. I'm sure as a counsel and as a lawyer, you must have read second appeal in CPC. And very clearly it says that the second appeal is not a matter of right. First appeal is matter of right. Second appeal is not matter of right. Second appeal only when there is a substantial question of law. So that part has been incorporated in now CPA 2019. That second appeal will be only substantial. And appeal from National Commission, if suppose you have filed directly before the National Commission, then the first appeal is Supreme Court. As I had already told you, section 69 and 69 postulates. If someone is keeping track of time, you'll have to warn me. Whoever is there. Someone has to tell me when I have to complete. So section 69 is the limitation period, which says 22 months, 2 years from the date of cause of action. As I was telling you, when you draft your petition, last date of your cause of action is the starting point of your litigation. So important here is section 69. The period of limitation. Now earlier in the old Act, it was 25 and 27, we get with penalty. Similarly here we have 71 to 73, which deals with penal consequences. Now what are the penal consequences? Imprisonment from 1 month to 3 years. Fine and liability, which can also extend up till, permit to read it, it's I was right, 1 lakh. And that's where they were given the power. Now here it is very important that it is executable in terms of decree of the court under Order 21 of the CPC. We all know Civil Procedure Code, and we know that Order 21 provides for execution. When I was reading this to give this lecture, and I was realized that there can be a contradiction now. Because this Order 21 Rule 56 postulates that a woman cannot be arrested for execution of a decree. Now that should be actually, it's a discriminatory provision, but whatever be the effect. So earlier when we had 25 and 27, Order 21 was not specifically mentioned in the Act. So I remember a judgment of Madras High Court where this issue came up, and the court said, sorry, it is under CPA and not under CPC, and so will not invoke this provision of section 56, Rule 56. But I'm sure that after this incorporation of Order 21, let's see how the court interprets that. But otherwise it is 1 year, 1 month to 3 years, 25,000 to 1 lakh. But though if you ask me, still in India, the law of consumer protection has to evolve much more. And what is important is that the court has to be realistic enough to give penalty and compensation, which creates fear in the mind of that seller. It's very, very important. Because till now the maximum compensation, like I was doing a bidder's case. And he said, sir, keep on fighting this case and we'll go till Supreme Court. I said, but you lose. He said, I don't care, I lose or win. I want to fight the Supreme Court. And you know what was his logic? And that shook me. His logic was that, sir, at best Supreme Court will give a compensation of 9%, which is the rule by now. I am using this white money of this person for my business where I'll turn out a revenue of minimum 25% on that. So from his money, I am gaining at least 16% per annum. I don't mind returning him after the Supreme Court. But court does not unfortunately realize that. You know, I still think that when we'll grow up that in the US, a case happened that someone purchased a coffee from McTea and she got her burnt because this was overly heated coffee. And she sued them and got $5 million as compensation. I'm sure in India, if we had gone, we would have got 500 rupees. So compensation, the court still has to evolve a lot. In fact, something was shown in Bhopal tragedy case, but that was of a such high magnitude that we cannot compare with every case of consumer protection. Okay. So they have brought in the enforcement mechanism in form of section 71 to 73. 73 is the appeal provision that you can file appeal. And if you show sufficient cause, then maybe the court will consider it to give you some lenient view. But otherwise, you will have to pay or go to jail. But as I say, though it's written very lucidly, sounds very effective, but the courts are most reluctant to send anyone to jail. Like I am doing a case where the person has not paid up from 2017 onwards. The court and High Court and Trial Court has passed several orders of non-billable warrants and arrest. But whenever he is arrested, somewhere the High Court or the Appellate Court stays in on equity. In fact, I have to argue that tomorrow because I was arguing this on Friday itself. And I said, look, every time if you have to show equity in his favor, please don't pass these orders. Why I should have a moonshine? And why this complainant should come to court every time thinking that, oh, this time my money will be raised, but I realized the money. And every time this is happening. So the court has kept it for further arguments tomorrow, in fact. So execution is two things where the court has to come strongly is the quantum of compensation. Because, you know, for this businessman, only one thing hurts, when they have to give money. And nothing else hurts them. And definitely the execution part. How fast and soon you can get your money. Because remember, you are fighting an institution, a big company. They have lawyers everywhere. They have lawyers of best caliber and quality. But this individual consumer does not have that kind of financial strength to fight up to the Supreme Court and keep on fighting. This practical reality and difficulty one has to understand. And by Supreme Court or High Court saying that we have a legal aid is not a solution, because we all know legal aid, a lawyer from legal aid cannot compete with the mights of a best jurist or a lawyer we have in the country. So, that's the end from 28 to 73, the journey of a consumer protection in individual consumers with 3 jurisdictions. Now comes is the mediation. As I was telling you that section 225 defines mediation, and mediation has been incorporated, ADR, Now from section 74 onwards till 79, it is all mediation. We don't have to go into detail because relevant or required, except that the ethos have been brought in that we have to try and aid alternate dispute redressal mechanism. And as a lawyer, it becomes our duty also to advise the client to find a solution through ADR, through mediation, rather than litigation. Like in Delhi, if the judge proposes a mediation, it's an unsaid rule that you will accept it. Unless until there is something on record to show that why you should not accept it. So once we complete this, remember here, there is one thing which has been incorporated already here, and that is your unfair trade practice. Defined under section 242, subsection 46, section 2 and onwards, 47, 48. Now like 246 says unfair contract. Now what is unfair contract? If Mr. X and Mr. Y enters into a contract, they negotiate it, there's a consensus ad idem, and then only a contract is executed. Very fair. But when you buy an insurance policy, have you read that contract ever? That fine lines. When you take a home loan, have you read that contract ever? The fine lines. When you go and buy a flat from a builder, does the builder change the contract for you? No. In India, till that judgment of DLF came, these builders' contracts were draconian. But I can point out at least 5 things because one of the first cases which I did against DLF was before MRTP on unfair contract. And the issues which I raised there was this. I said, A, it does not specify what is the site plan and floor area. It says subject to change. 2, it does not define is to be provided and how it is to be chargeable. It has again left open and at their discretion. 3, they say that we will provide this within 3 years, but they also say that it can be extended to any period for reasons which is, for reasons also they would not bring in some force majeure clause. So time, which is the essence of the contract, became diluted. Now, they also you cannot bring any unreasonable conditions. Now, unreasonable condition becomes a very wide umbrella, definitely. Similarly, you have section 247. No one is speaking how much time I'm left with because I thought that we have to finish it. 8:30.
See, Sanjeev,
Rajesh.
I think you are already very tired, and it has been a very long session. So I think we would request you to hold another session on it.
Okay.
At your convenience, whenever you feel like, because several people have sent me WhatsApp messages requesting this, that you should conduct some other sessions as well.
Okay.
Or any topic that you feel like.
Okay. So, Rajesh, can you give me 5 minutes? What I do is, I will speed up my process and complete the topic. Okay.
Yes. Only one thing, that about the pecuniary jurisdiction, I had only explained till 1986 Act. So kindly update them.
So I was saying that pecuniary jurisdiction now is 1 crore, less than 10 crore and above 10 crores. Okay. So if you read the section 34, I'll just open it for reference. And it says that, and similarly you will read section 47 and then there. So it says what? Section 34 says that not exceeding 1 crore. So anything which is less than 1 crore will go to district forum. Similarly, if you see section 47, anything which is not exceeding 10 crores will go to state consumer forum. Above 1 crore, less than 10 crores. Anything above 10 crores will go to national consumer forum. That will be, as I was telling you, because of Justice Chandrachud's judgment, prospective in nature, that all the fresh cases you will find, and not the cases which has already been filed. Now, permit me to just speed up. So what I'll do is, like I was mentioning you the example of Bhopal tragedy and that airlines case. What was there in India? We did not have the product liability, or what we call strict liability. We all must have heard caveat emptor, means buyer beware. Have you heard caveat vendita, means seller beware? And that is important. In fact, I was remembering that I was giving lecture in Miranda House long back again. That was in 2013 or wherever, and I had raised this issue there also. And where it will be that the buyer should be, seller should be beware. And that has now come with your introduction of this product liability, service liability, and seller's liability. Now here there was a very important case. The first case of this nature was definitely a coach factory case, which I am leaving it because that was denied, but a Buick case. He purchased a Buick car. There was a problem in the handle. He sued the manufacturer. Manufacturer took the plea of privity of contract, stating that, look, you have not purchased from me, you have purchased from the seller. And so I am not responsible. Justice Cardozo, and we know almost that Justice Cardozo, he was one of the, like, telling you have in England, you have Justice Cardozo in US for this kind of laws, equity-based, tortuous-based and all. So he said, no, privity of contract is not important. You have manufactured it. You are responsible. Only thing what the consumer has to prove is that A, he has not got it free, and B, it has caused injury or harm to him. After that, there was a judgment of, this case was with regard to, this was a shopsmith. So this was shopsmith case was where the person purchased equipment which would saw, drill, and cut woods at the same time. Again, in this case, the court held that, look, it is a case of product liability. Coke has also faced the case of product liability on similar situation. In India, we have two examples before this act, which is very, very significant. One is that Bhopal tragedy case. And there also the opposite side, UCC, Union Carbide, took the plea that, look, the company is based in US, so you go to US and sue them. And B, they took the plea that in India you don't have a case of product liability or what you call a strict liability. And so no damages or compensation can be paid. Similarly, what happened is that there was an airline. There's an Airbus industrial case. In this case, the flight was going from Bombay to Bangalore. It crashed at Bangalore airport. They were sued. Again, the same plea was taken. Product liability, no strict liability. It is company registered in Texas. So India said, Supreme Court said, maybe company is...
Sir, excuse me. So there is a professional liability for Indian Airlines or whatever the airlines, Airbus.
Yes, so?
Airbus have already the professional liability. If the Airbus got crashed, they have the professional liabilities. They can claim with the insured, right?
Mm-hmm. Look, here
They can pursue
the Airbus, which has been sold to the airlines, and airlines is flying it, or airlines is flying it under the license. This is the Karnataka.
I can tell you the manufacturer is Airbus, and they have their professional liability for minimum 7 years.
Correct. But the question what they raised was threefold. A, that we are in Texas, you come to Texas and sue us. And that's where in 1994 this concept came in. That they cannot be only because we don't have a strict product liability case. And so you cannot be sued. And similar plea was taken, in fact, in Union Carbide also. And both times the Supreme Court had struck down. Now, fortunately, we have the law in place. Okay. So, they have this product liability, service, and seller. It has three parts. So, product liability, we are manufacturer. Service part, when we hire services, like bank, insurance, transport, anything. And seller. Even seller can be sued if he has modified the product, if he is selling the product where he claims to be independent of the manufacturer, and there are other qualifications also. So this product liability has been brought in. And this is a very, very important.
Okay, sir, I understood.
Correct?
After 74.
Yes. No, that's perfect. I mean, look, I like interaction, so don't worry. Okay.
It should be interactive session, sir.
Yes. Next time we will actually possibly, I should know my time, then I'll give 20 minutes for question answer, because that will become much more interesting. Okay.
Thank you, sir. Thanks a lot.
Yes, well, I mean, so now this is important part of it. The other aspect that also has been brought in is e-commerce. Where there is e-portal like Amazon, Flipkart and all. Earlier they used to say we are not liable because we only provide the portal. But then the concept of intermediaries came in. And thereafter there's a judgment of Delhi High Court came this as I think just before the lockdown it came in fact. March of 2020 it came, and they said the intermediaries cannot run away. And they have the responsibilities and liabilities which they will face. And definitely this CPA, they make it very, very clear that not only they should have a strict policy of pricing, refund, replacement, guarantee, warranty, and most importantly, one more thing which is happening now. They should have an authorized representative within the country. What they call is a person which is called a grievance officer. He will become the responsible person. You will not take the plea that I am in America.
No, there is every corporate, there is a grievance cell.
Yes.
Exclude their toll-free number and even with the email ID, so that you can complain, and whatever the grievances that we have, that we can complain over there.
Yes. And then you will know that how Twitter was fighting in Delhi High Court that will not have it. And finally the High Court said we are not going to give you any stay or caveat, you jolly well have it.
Right.
So it has become, now the act has become, I have concluded the act, I am not looking at the miscellaneous process because I have covered them all. So I understand that this act in every manner has been very progressive in nature. It has really taken care of the current economic situation with digital platforms and everything coming. Now, important thing is left is that how the courts interpret it. And as a lawyer, we should be strong enough to keep on fighting with the court. As a lawyer, we should always keep on fighting with the court. But like I said that, 9% has been made, an interest rate has been made a rule. But 3 days back, Supreme Court in Unitech case granted 12% interest. We were happy because I was just arguing a case in Delhi National Commission for a Chief Secretary of Delhi retired. And the court was saying you take 9%. I said, why should I take 9%? I paid in 2013, all money white. Nothing has been done by them. So that is there. How the court interprets and how the lawyers keep on forcing. But if you see the ambit, it's a very, very nice act. And as I said that, if as a lawyer we keep our perspective clear, as I said, 5 points of drafting and 2 salient features. Read the act and read the judgment. As a lawyer, you will never fail. Thank you so much.
Thank you so much, Sanjiv, for addressing and guiding the advocates and some law students as well who have attended. And I'm very surprised by the enthusiasm that they have shown for this kind of lecture. Actually, these lectures are very important and would definitely prove to be very beneficial for them. Our endeavor basically is to raise the standard of lawyering over here in Jharkhand, because unfortunately, the circumstances over here in the state you are well aware of.
Yes.
यहाँ पे कुछ अच्छे बुक्स की कमी हो जाती है और भी बहुत सारा कमी है जो कि हम लोग सब समझते हैं. तो और अभी पैंडेमिक सिचुएशन के चलते क्लासेस भी बहुत ज्यादा अच्छे से नहीं हो पा रहे हैं और उनके एडवोकेट्स को मौका भी नहीं मिल रहा है खुद जाकर के टू हैव द एक्सपीरियंस. So I thought of yes. So I thought of
it was a very may I. It was a very nice opportunity that we have got, that Mr. Sanjiv has really told us about what the current scenario is going on regarding all these things. It was very nice session, sir, and it may be continue for the next schedule, whatever the Sanjiv sir is given, and we will have the interactive session regarding this, sir.
No, we will have it. Now once we have that time, we'll
another schedule. Please give us the schedule for another time, sir, also.
Yes, we'll work it out. I will have a work with Rajesh and we'll see how we'll work it out next time.
Thank you, Rajesh sir. Thank you, Sanjiv sir, for the nice and precious time and grateful the speech is.
See, actually, we should all thank Sanjiv only, because I too am based in Jharkhand and I am doing these things from time to time.
You are only coordinated for the same, and we are highly obliged with Sanjiv sir that giving the precious time.
Yes, we are, in fact. And anyone else wants to have a word or has any confusion about this, whatever Sanjiv has said?
Actually, whatever the act has been dealt by Sanjiv sir was brilliantly and with the practical example. So it was very easy for us to understand the things in better way. And we are so happy to listen these act and the examples which has been provided, like Bhopal Gas Treasury, and after that product liability and district liability came, and the rules and the act till 72, and we will be able to now deal with this, and we can explain the things in better way, whatever dealt by the sir. So thank you, sir.
Anyone else has any question or something? Any question or any suggestion?
Yes, sir. I have a question. I have one question.
Please go ahead.
Hello. Sir, there is one question. So compensation and punishment for any unfair trade practices and consumer protection exploitation?
Sorry? There is compensation provided. Yes.
Yes, sir, compensation and punishment.
Yes. Compensation and punishment is there. So if you see the unfair trade practice, if you see the section 38, the entire relief with regard to unfair trade practice is provided there. And the punishment under section 71 and 72 is from 1 year to 3 years, 1 month to 3 years. So the punishment is also there. It's not only cease and desist any longer.
Mostly the trade we cannot call them under the court. Reason being, they have lot many terms and conditions which we are going to agree either digitally or verbally also. So there are lot many problems with the trade fair so that we can call them in the court.
No.
They have terms conditions, sir. They have terms and conditions for everything.
Hold on. You see, forget about this Nirma's and Colgate's judgment earlier we used to have. Okay? And MRTP Act. This
Nestle, whatever the judgment given in favor of that Muzaffarpur guy, that is also comes under the terms and conditions. That is also compensated just because there is the emotional attachment with the product.
Irrespective, both situations, according to me, is well covered with under 39. Right. And as I said, unfair will not be restricted only to cease and desist, which was earlier the rule. Okay.
Okay, sir. Anyone else? Mr. Amar was.
Sir, I have a question.
Sir, I have one question. Sir, I just wanted to know.
Yes, sir. I have a question regarding.
Sir, that you mentioned.
Hold on, Mr. Amar. Let Nikita ask. Let ladies first.
Thank you, sir. Sir, I have one
Okay,
question
sir.
from Sanjiv, sir. So you mentioned one word caveat, and after that, that means the seller should be aware. So what was the word caveat?
What was the word which I gave you?
Caveat.
She is saying caveat emptor I gave, and then which word did I give her? The next one, which is there.
Which means that seller should be aware. I just wanted to know that what was very useful.
So that is caveat venditor, and that is the spelling which you will get is, I'll just tell you the spelling. So this is VENDITOR. That the buyers beware.
Thank you, sir.
Yes.
Acha. Mr. Amar.
Yes, sir.
Yes.
Yes, sir. Sir, I have this question regarding the applicability of CPA. I have this question regarding this applicability of CA. It is applicable when there's not a commercial, it's not used for commercial purposes. For example, I'm a wholesaler. I'm purchasing something from the stockist, and I have a grievance in the transaction. So would I not be covered under the CPA? And if not,
I can understand that you are now muted or whatever has happened. So you are trying to say that you have purchased it for resale.
Resale can
right, sir.
Now resale will again, though if you see the word in CPA, for the purposes of resale, there is a strict bar. Okay, that if you're purchasing for a commercial purpose and for resale, but the moment you purchase for resale, then it's for commercial purpose, and then you don't remain a consumer. So there will be a huge problem. But otherwise, you definitely have a civil liability. You definitely have a civil liability. You cannot.
But still, I think the need. But still, sir, you can, the term consumer can have multiple implications. I am a consumer for the stockist.
Consumer,
the transaction goes on.
Amar, consumer का मतलब होता है वो consumes. Though why I am also restricting my answer is because I am again saying, thinking on the line, sometimes when one has to argue and see how, as a lawyer, I can expound this and I say कि भाई तुमने मुझे एक गाड़ी को मैं टैक्सी की तरह रन कर सकता हूँ and I can earn some money from there. And similarly, if I am a very small grocery shop owner, can I invoke the same analogy and go to consumer court? I'm thinking aloud. Otherwise, I would say that it's completely commercial and you are not there. But I'm thinking that, for small grocery sellers or whatever, बहुत छोटे से लोग हैं, उन लोग के लिए तो होना ही चाहिए.
इसमें सेल्फ एम्प्लॉयमेंट का क्लॉज कुछ है ना?
Yes.
सेल्फ एम्प्लॉयमेंट के लिए अगर आप उसका इस्तेमाल कर रहे हैं तो आप उपभोक्ता की तरह इस्तेमाल कर रहे हैं. जैसे आपने गाड़ी खरीदा, गाड़ी परंतु आप उसका इस्तेमाल कर रहे हैं सेल्फ एम्प्लॉयमेंट में, टैक्सी के रूप में चला रहे हैं, तो यू आर वेरी मच वो उसको आप कमर्शियल यूज नहीं माना है. इसलिए आप उस हिसाब से
small grocery shop may be running his shop just for their identity, just with their identity, but the big one is doing it commercially and they have the GST license and everything. In that particular case, they can apply. The small grocery shop can also apply for the consumer law.
And that will depend on facts and circumstances of the case, which varies from case to case. तो वैसा वाटर टैंक कंपार्टमेंटलाइजेशन नहीं कर सकते, लेकिन कंज्यूमर प्रोटेक्शन एक्ट का मतलब है कि कंज्यूम कर रहा है वो तभी वो कंज्यूमर है और तभी वो इस एक्ट का जो है वो प्रोटेक्शन ले सकता है. अदरवाइज कमर्शियल वाले को बहुत ज्यादा अगर स्कोप दीजिएगा तो फिर ये कंज्यूमर प्रोटेक्शन एक्ट का जो पूरा यूटिलिटी है और पूरा जो ये है सारा वो डाइल्यूट होता चला जाएगा, है ना? So,
They can also stand up with the consumer also. They can also stand up with the consumer also, sir. In that particular case, that single particular case, अगर consumer को करना है, तो वो छोटे दुकानदारों से भी they can apply the case and they can file the case against the owner or the go down in charge or whatsoever company owner.
See, we can do
Without in charge and all. Again, if you are using go down as an example, it can be totally different. If I have raised the insurance as a company, even if I am doing a commercial transaction, it's different. For what purpose you have done the purchase the product, it defines that. So you have to go by facts of this. You can't have a simple straight line answer to it. Like I did a case for Shri Cements. And there the issues, they said, I am a consumer, commercial. I said, well, I am a commercial company, but I had taken the insurance. And that insurance service will not fall under this definition or exclusion of commercial.
Yes.
Right, sir.
Yes.
And the point is, lawyers का तो ये काम है कि भाई वो law को अपने हिसाब से कोशिश करेंगे लाने का, अगर scope है तो.
मेरा एक क्वेश्चन था.
Right.
I wanted to ask one thing. फ्रॉड होता है अगर किसी चीज को लेकर के,
ये जो भी लोग क्वेश्चंस पुट कर रहे हैं, थोड़ा सा आइडेंटिफाई कर ले अपने आप को कि हम लोगों को पता चल जाए कि वो उनका नाम क्या है और वो.
My name is Swati. Sir, my name is Swati. I just wanted to ask you, sir. The sir has given an example of DLA, so I just wanted to know if there is a
not only the name, but also whether you are a student or you are a lawyer already.
No, I'm not a lawyer. I'm a student only. I just wanted to ask one thing. If somebody has made a fraud on a land, किसी लोगों से किसी land को दिखाया and they have made a purchase of 100 people, and after that it comes to the conclusion that the land का जो purchasing था वो wrongful position था. Owner denied कर रहा है, but they have taken the money. The middle party has taken the money. So ये sir, this type of whatever ये भी जो भी विवाद से जो भी आता है, तो उसको हम एड्रेस किधर करेंगे? तो कंज्यूमर फोरम में करेंगे या हम सिविल कोर्ट की तरफ जाएंगे? जैसे आपने वो डीएलएस के लिए बताया था ना सर कि डीएलएस में ऐसा
that comes under liability and assets. Liability and assets matter over there.
Amit, let the resource person answer. Let the resource person answer.
So there are three things primarily. A, you can definitely file such kind of fraud. You can file a criminal case also. That's one. You can come under the consumer court also. There's no problem. You can go under RERA also. There's no problem. Because whatever Mr. Presentation.
What is the best way where we can file it? Mostly ऐसे cases आते हैं सर. ये लोग fraud करते हैं इस तरह से.
देखो, best way तो there's no best way, but at least two things you should do. One, you should do the civil liability invocation, either consumer or RERA, and you go to the second part which is there, which is your criminal. Then enforceability is faster. Otherwise,
criminal में भी जाने के बाद तो सर उसको सिविल में तो आना ही पड़ेगा ना. At last तो ये सिविल मैटर हो जाता है ना सर.
Absolutely हो जाता है. That's why I said two at least.
Okay. Okay sir, thank you sir. वही है तो बहुत confusion था.
एक रिक्वेस्ट है मेरा और संजीव से और बाकी लोगों से भी कि काफी लोग आर मोर कंफर्टेबल इन हिंदी. तो जो हिंदी में कंफर्टेबल है वो हिंदी में बिंदास एकदम से पूछे.
हिंदी मैं भी बोल सकता हूँ.
दिल्ली के ऐसा हिंदी और इंग्लिश सब बोल सकते हैं क्योंकि केसेस तो सारे बात दोनों आते हैं.
हम झारखंड के हैं प्रॉपर.
हाँ सर.
हमको कोई प्रॉब्लम नहीं. वो दिल्ली आके अब वो थोड़ा सा हमें बोलना पड़ रहा है क्योंकि कोर्ट में बोलने की आदत पड़ रही है इसलिए.
Yes sir. I can put my answer in English also, but I think my most comfortable way to tell you is in English. So that's why I.
हमारी मदर टंग है. We should be proud of it.
Okay sir.
ठीक है. Okay, so we done with, or we have more questions?
Sir, I have one question.
Priyanka?
My name is Raju sir.
Yes, Priyanka.
Priyanka, you go through.
प्रियंका बोलिए.
Sir, excuse me, I don't have any question. I just want to thank. It's a privilege to have this class. And thank you so much, Sir Sanjiv and Sir Ranjit, for conducting this class and providing us your precious time. Thank you so much, sir.
Thank you.
Excuse me, sir.
Raju.
Excuse me. Yes, sir. My name is Raju, sir. Okay, I have one question. Any person purchasing something and we feel that, then there's some problem occurred, then where and how should address his grievances?
Means, look, your question is too vague. Okay, you will have to put it like you are saying now where and how. I had already explained that section 34 is where, and how is section 38 of the Act.
Okay.
Where you will find is your jurisdiction, territorial jurisdiction. ठीक है ना? अब वो टेरिटोरियल जुरिडिक्शन आप जहां पर रहते हैं वहां फाइल कर सकते हैं, जहां पर कॉज ऑफ एक्शन हुआ वहां फाइल कर सकते हैं, जहां पर अपोजिट पार्टी रहता है वहां फाइल कर सकते हैं. ठीक है? और कैसे फाइल कर सकते हैं वो भी उसी प्रोविजन में सेक्शन 38 में प्रोवाइडेड है कि आप ई कंप्लेंट भी कर सकते हैं, आप फिजिकल कंप्लेंट भी जाके फाइल कर सकते हैं, और कोर्ट कैसे करेगा वो भी मैकेनिज्म वहां पर प्रोवाइडेड है.
जी सर.
अच्छा, I have a request now.
धन्यवाद सर. थैंक यू सर.
वो सर वो जूम का जो दूसरा रूम बना था उसका अब सेशन एक्सपायर होने वाला है, तो I would now say कि अब संजीव भी you must be feeling very tired now.
No, I have a long day tomorrow.
It has been a long time, long session. Thank you so much, and we'll definitely coordinate for these enthusiastic people. Thank you all for attending.
I appreciate everyone. I see so many people have combative questions, very interesting, and appreciate. I totally appreciate that, because many times I have done conferences, very few people come up with questions. Very few people will come up with questions. So very nice. Thank you.
Thanks. पूछिए. वेट कीजिए. अच्छा, जो लोग अब जाना चाहें जा सकते हैं. द सेशन इज कंक्लूडेड. अब जो रहे वो अपना पूछ सकते हैं जब तक चाहे तो. और अब मेरे ख्याल से अब संजीव जी को ये लास्ट क्वेश्चन ही रहने दिया है.
हाँ, लास्ट क्वेश्चन करते हैं. हाँ,
ओके, प्रिया पूछिए.
सर, आरटीआई का रेट्रोस्पेक्टिव इफेक्ट जानना था मुझे. मैं इसको क्लियर नहीं कर पा रही हूँ. ये क्वेश्चन था मेरा.
क्या चीज?
आरटीआई का इफेक्ट कैसा होता है? रेट्रोस्पेक्टिव होता है या प्रोस्पेक्टिव होता है?
आरटीआई का?
हाँ, राइट टू इंफॉर्मेशन एक्ट.
वो बाद में हम लोग सेशन करेंगे प्रिया.
सर, आई हैव अ क्वेश्चन रिगार्डिंग दिस. आई एम स्टक समवेयर, सो आई एम आस्किंग यू.
आप पूछिए.
यू कैन रिप्लाई देम.
क्या क्वेश्चन क्या है आरटीआई में?
आरटीआई का इफेक्ट जानना था कि इसका इफेक्ट रेट्रोस्पेक्टिव होता है कि प्रोस्पेक्टिव होता है.
क्या आरटीआई का
इफेक्ट रेट्रोस्पेक्टिव इफेक्ट.
तो आरटीआई का रेट्रोस्पेक्टिव इफेक्ट क्या होगा? आरटीआई का मतलब है कि राइट टू इंफॉर्मेशन.
यस सर.
तो राइट टू इंफॉर्मेशन, जो इंफॉर्मेशन है वो पुराना इंफॉर्मेशन है तो भी आपको उसका अधिकार है.
और जिस दिन तो प्रोस्पेक्टिव हो गया ना, आप तो मांगोगे उस दिन प्रोस्पेक्टिव ही है वो.
हाँ, वो उनका दिया गया है.
बोथ टाइप ऑफ इफेक्ट है ना.
क्या बोल रही हैं?
इसका इफेक्ट रेट्रोस्पेक्टिव और प्रोस्पेक्टिव दोनों होगा ना?
नहीं, रेट्रोस्पेक्टिव इफेक्ट का बात नहीं है. बात ये है कि इंफॉर्मेशन जो है वो तो इंफॉर्मेशन है, वो पुराना इंफॉर्मेशन हो या नया इंफॉर्मेशन हो. राइट. तो आज जब आप मानिए अगर वो इंफॉर्मेशन है तब तो वो रेट्रोस्पेक्टिव के एम्बिट में नहीं आएगा, वह प्रोस्पेक्टिव के ही एम्बिट में आएगा. कि आज आपने मांगा, क्योंकि 2005 जब भी वो आरटीआई बना कानून है ना, अब उसके बाद 2005 में मेरे ख्याल से वो एनैक्ट हुआ. अब उसके बाद ही ना आप एप्लीकेशन फाइल कर रही हैं. तो वो तो प्रोस्पेक्टिव ही एप्लीकेशन, प्रोस्पेक्टिव इफेक्ट हुआ, प्रोस्पेक्टिव ही आपने एप्लीकेशन फाइल किया आफ्टर द एनैक्टमेंट ऑफ दैट, है ना. अब जो आप इंफॉर्मेशन मांग रही हैं वो अगर मेडिएवल एज का भी है, एंशिएंट एज का भी है, पाषाण युग का भी है, तो भी वो इंफॉर्मेशन है और वो उस पर आपका अप्लाई करेगा वो।
करेक्ट।
ओके,
राइट।
थैंक यू।
So let us conclude with this.
अजय सर एक और क्वेश्चन दे रहे थे। हेलो हेलो सर।
Yes, yes.
हेलो सर, दिस इज द लास्ट क्वेश्चन। मैं पूछना चाह रहा हूँ सर कि जैसे मैंने अमेजन से कोई ऑर्डर किया और पेंडेमिक की वजह से मेरा मान लीजिए प्रोडक्ट रिफंड हो गया, सपोज मैंने उसको प्रोडक्ट गलत आया रिफंड कर दिया, और अमेजन जैसे अभी जो पेंडेमिक है तो बंद हो गया था सर्विस सर, तो लॉन्ग टर्म होने की वजह से मेरा आइटम तो रिटर्न हो गया लेकिन रिफंड नहीं आया मैम सर, और पैसा भी नहीं मिला, तो इस तरह के केसेस में क्या करेंगे क्योंकि बीच में तो पेंडेमिक था।
इसी पैंडेमिक में और लॉकडाउन में has nothing to do with refund of money. It is also electronic mode. It can be a delay of 1 day. It can be a delay of 2 days. It cannot be a delay of several months.
मीन टू से जैसे प्रोडक्ट रिसीव किए सर, बाद में पता चला मेरा प्रोडक्ट गलत है, जैसे ही हम रिटर्न किए उसके बाद पेंडेमिक का लॉकडाउन आया सर, लगातार लगा गया मान लीजिए बहुत टाइम, तो फिर उसमें कैसे चले?
केस कर दीजिए, कंडोनेशन ऑफ डिले का एप्लीकेशन होता है, उसको लगा दीजिए।
Correct.
तो इसके लिए टाइम लिमिट होगा ना सर, मतलब कितना टाइम तक मैं कर सकती हूँ?
कोई नहीं, आपको जिस दिन आपने रेज कर दिया, अगर आप वो नहीं सॉल्व कर रहे, आप जैसे बोलता है क्या, अगर ड्यू एक्ट में देखिएगा तो बोलता है रिड्रेसल शुड बी विद इन 48 आवर्स। अगर रिड्रेसल विद इन 48 आवर्स नहीं हो रहा है, आपके पास कॉज ऑफ एक्शन है, आप चले जाए।
अच्छा, ये लिमिटेशन पूछ रहे हैं कि भाई कब तक कंप्लेन फाइल कर सकते हैं?
मतलब सपोज सर उसका टाइम मतलब 6 मंथ्स एबव हो गया सर, तो मतलब मैं जानना चाह रहा हूँ कि इसका टाइम लिमिट कुछ होगा सर?
एक मिनट, हाँ सॉरी, लिमिटेशन का ये है कि जब से पैंडेमिक हुई है 22nd of March 2020 till 28th of February 2022, कोई भी लिमिटेशन काउंट नहीं होगी बिकॉज ऑफ दैट जजमेंट ऑफ सुप्रीम कोर्ट। ओके,
थैंक यू सर, बस एक डाउट था सर।
तो कोई लिमिटेशन काउंट नहीं होगी। आपकी केस डिसमिस अगर हो गई हो मार्च फरवरी 2020 में, आप अभी भी जा सकते हो अपनी।
ओके सर, थैंक यू फॉर द आंसर सर।
ओके, ठीक है।
Let us conclude and let us say good night to each other. All of us.
Yes.
Good night sir also.
Good night.
Good night sir.
Thank you so much.
Good night.
Thank you, sir.
Good night, sir.
Thank you, sir. Good night.
Good night sir.
Thank you, sir.
Thank you sir.
Thank you, sir. Good night.